So I can dig in your affairs, Al. I can find out exactly how much money that you have stashed away if you were to pass away.
Well, you can't me because I got a living trust.
Well, you're sitting next to a man that probably helped you out with that.
He did help me out with that. And with that, I'd like to introduce Tom Lawler, who has been our estate planning attorney, associate, I guess, with Pure Financial for quite some time. And Tom, welcome to the show.
I'm glad to be here, Al. Thank you.
So I got the burning question on everyone's mind, which is, should I get a will or a living trust? What do you say to that?
Well, I get that question all the time, Al, and I answer it with a question. I say, do you own a home here in Southern California?
Okay, and I do.
And you do, and if you do, I'm going to say you need a living trust because you have too much.
Living trust because I have too much. What does that mean?
Well, basically, if you own real estate here in Southern California, the most you could have is $150,000.
And most homes here are more than $150,000.
Well, the 150 isn't net, it's gross value.
Got it, got it.
So
if you have $1 million home and you got a $950,000 mortgage, it doesn't count as a $50,000, they count the gross amount.
yeah, sadly, it's like a real estate deal. They base the commission on the gross value, not the net.
And so it'd have to go through probate, and then there's all kinds of fees to pay through probate. It's a public matter, it takes a while, so you really would rather have a trust in that situation.
Yeah, the idea behind the trust is to avoid those things. You want to go inexpensively, privately, and quickly, and that's really what the trust does for you versus the probate, which might last a year.
Got it.
It's public in nature, so they can find out, like Joe said, what you have, where it's going, who's it going to, who's not getting it.
Okay, so this living trust sounds pretty good, but there's different kinds of living trusts. Why don't you explain that?
Yeah, so all the living trusts are set up to avoid probate and conservatorship. That's the issues we've been talking about. Those are state court issues. Simple trust, AB trust, and disclaimer trust. Those are the basic three that we use over and over.
So who would use a simple trust?
If you're a single person, non-married person, you'd use a simple trust.
Okay. So if you're married, you might consider an AB trust or a disclaimer. So why don't you briefly tell us what those are?
Yeah, the AB trust is primarily set up to use that first spouse's estate tax exclusion. So to get that exclusion at the first death, you have to split the trust into two parts. We generically call them A and B. We call them decedents and survivors in our trust. But the idea is we want to get the decedents half of the estate in the decedents trust and apply their exclusion to it. So we've actually used it so that when the survivor passes, it's just their portion of the estate that's potentially subjected to taxes, and they have their whole exclusion to apply against it.
So, and with the AB trust, you essentially have another tax entity. You have to file a trust return at that point. The survivor does.
Yes.
So now you have half the assets in that trust and half the assets in the original living trust, which is a flow-through where you don't have to file.
True.
Now, what about a disclaimer trust? What does that do?
The disclaimer trust we've been using a lot more lately because it's a more flexible trust. One of the problems with the AB trust is even if you don't need that first spouse's exclusion, if your estate's $1 million and the current exclusion is $5,430,000, you still have to split the trust. That means getting the values of the assets, deciding which assets go in which trust, and then actually running around and re-registering all the assets, getting a tax ID, filing tax returns. So that's required with an AB. Disclaimer trust, on the other hand, you have a choice as the survivor. You can choose, based upon the circumstances, the size of the estate, the size of the exclusion, to do nothing, which would be great. And so if the estate isn't that large, you can simply do nothing. It stays a simple trust, it defaults to that, and you just carry on. But on the other hand, if your estate is large enough, then you have the ability as a survivor to split that trust into that AB trust.
So the disclaimer trust gives you the ability to split it if you want to, but you don't have to. And if you don't have to, it's much simpler.
Much simpler.
So that's a good way to go. So Tom, fantastic. You made this complex subject easy to understand.
I'm happy to help.
And so I'm going to say, if you want more help on estate planning, go to our website. I think it's on the screen, Your Money, Your Wealth TV. You can find out more about us. You can find out more about Tom, and get some more information about estate planning. Make sure you do this stuff right.